Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in the state of Michigan, and we have a basic goal with these videos, and that is to educate the public on issues that are significant to them. So please subscribe to our channel so that you can receive the benefit of that education. Today we're going to talk about some strategies in negotiating divorce asset allocation. Now, in a situation where the parties have liquid assets and we're dealing with a 50-50 split, this is rather simple. You got $100,000, you're getting $50,000, the other side's getting $50,000. That's it. It becomes more complicated when we have assets that are part liquid and part non-liquid. We have liabilities coming into play. We have potential liabilities. We have debts. We owe Visa, MasterCard, IRS, medical bills, all of these things. Then the question becomes, how do we do it? You have to understand one thing. This is very important. Just because the court is going to try and divide the assets in an equitable manner does not necessarily mean they're going to divide it in an equal manner. Equitable is sometimes equivalent of the word equal manner. Sometimes equitable doesn't mean equal. It just depends on the circumstances of the parties. So if you've got, let's say, a lot of assets and you've got certain assets that have a value, but dividing them will immediately result in a diminishment of value. So for example, let's say you have a 401k. If you were to divide that right now, there would be perhaps an early withdrawal penalty. There might be a tax consequence. That 401k, if liquidated, might be worth considerably less. Or maybe you have a home. It's worth $200,000. But is it really a $200,000 asset? I mean, once we sell it, we'll have to pay transfer tax. We'll have to probably pay 6% real estate commission. All of a sudden, that $200,000 house is now worth $160,000. So we don't necessarily have the gross amount, half for you, half for that, and that's not necessarily how it works. But what we can do is try to figure out and take into account the absolute value of those things, bearing in mind the attendant debts that go along either with that asset or with another asset. Suppose, for example, we want to divide all the assets and we have a 401k or some retirement plan. Now, sure, we could evade that plan, and just let the cookies fall where they may and just divide it that way. Or we can leave it in place and set it off against another asset. Perhaps if husband is supposed to split the 401k but doesn't, then he's got to make up that half value to the wife in a different form of asset. So maybe he gives more of an asset or takes on more liability to cover the excess. And so there are all different ways that the skilled attorneys can look at the assets and tweak them in order to make it fair. Now, every case is very fact specific. Your case may be a little bit different than the next one. Therefore, if you have questions about that, reach out. We'll be glad to help you out.